So, first of all, thank you everybody for joining this webinar. As everybody know, today's agenda is privacy and data protection. And this has been a very crucial topic for business community. And now it has become more prominent as India is coming with some new policy for data protection. So to give insights on that, we have Akshaya Suresh, and she works as partner at CLA. Akshaya has more than 15 years of experience, and she has worked with companies like Freshworks and J. Sagar Associates. Apart from that, she has expertise in the field of technology law, uh, data security and protection, commercial contract, and a lot more. So without wasting much time, I will request Akshaya to please take it over from here and give an insightful session on this. Thank you.
Thank you, Vikas, and hello to everyone. Thanks for joining. In today's webinar, we are going to go over how startups need to approach privacy and data protection. Many times it can seem very daunting because there are so many laws that apply and it says so many things. It can seem overwhelming as to where do I start in the journey of compliance? What should I do? So in this webinar, I've tried to simplify it and provide a starting point, a framework, which startups can use for compliance with privacy and data protection. Let me share my screen. Now, businesses today process a large amounts of data. It could be from your customers, it could be from employees, it could be from your prospective candidates, website visitors, event visitors, channel partners, vendors. There is data that is collected at many touch points from many people across the world. And businesses today, they operate on a global scale. They are not restricted to just the US or EU or India. Yet the laws that apply to protecting an individual's personal information are still local. So you have GDPR in the EU, you have a GDPR in the UK, you have CCPA in the US, you have SPDI in India and an upcoming data protection bill, you have the Australian Privacy Act. So a lot of the times, early stage or growth companies, they wonder, where should I start? How can I comply with everything? And should I know everything? Should I make lists for everything? How should I start? What is my responsibility? And how do I do it in a way that makes sense to me practically, operationally, as well as protects the rights of individuals? And many companies use GDPR, which is the EU law on data protection, as the baseline for compliance. So that is where most businesses start. Laws across the world, including the one that hopefully comes soon in India, are based on certain principles of privacy. So what are these principles? It's important to understand these principles so that you know you can devise your approach on dealing with personal data. So firstly, personal data should be used fairly and lawfully. You should not collect data by unlawful means. If the law says you're not allowed to hack a database and copy data, you cannot do that. That is unlawful. So personal data should first be used fairly and lawfully. Second, it should be used for limited, specified, and lawful purposes. So when you have someone's phone number or email because they have signed up to your product, don't use that phone number to simply call them out of the blue for other things, for other reasons. Make sure you know why you are collecting personal information, for what purpose, and stick to that purpose. The third is make sure you're only collecting personal information that is relevant for the purpose for which you're collecting. For example, you don't need to know someone's food preferences when they're signing up to a product. So You don't need to collect that. You shouldn't collect that. The fifth one is data. There should be some health check for the data. Data should be accurate and it should be kept up to date. Now, why is this important? When the information about you is outdated, decisions made on based on that data is also outdated. Uh, for example, let's say you had a health issue which you no longer have, but your employer keeps making decisions based on some old data they have about your health situation. That's going to adversely affect you. The data should be kept up to date. That's the fifth principle. And data should not be kept longer than is necessary. This is the principle of data retention. Don't unnecessarily store data. It's going to get outdated. You increase the risk of breach and you put people's information at risk when it's not needed. So keep the data only as much as it's necessary. So these basic principles should always be kept in mind. You will hear some terms often when talking about personal data. So the first question is, what do we mean when we say personal data? So personal data means any information about a natural person. Companies don't have privacy, only individuals, people have privacy. So it's data of a natural person. And it's any information that identifies a natural person, or when a person is identified or identifiable, all that information becomes personal data. You will also keep hearing data subject. Data subject's right. You should inform the data subject, take the data subject's consent. So what do you mean by data subject? So the individual whose data you have is the data subject. We'll also often hear the term processing. Now, what is processing? It's a very wide term. Simply put, anything that you do with data is called processing. It could be access, it could be use, storage, transfer, disclosure, deletion, anything. You'll also often hear the term controller. So controller is the person, natural person or the entity that collects data in the first place and decides what to do with it. It makes a decision on the means and purposes for using and processing personal data. They are the controllers. For example, when you go to a website and they collect some data from you, that website owner is the controller. You will also hear the term processor. So any entity that is processing data on behalf of a controller is a processor. For example, many SaaS companies use cloud service providers to store data. And these cloud service providers store data on behalf of the company. So they become a processor. Okay. So these terms are important to understand because what measures you need to put in place or what controls you need to have also depends on what role you play. When you are the controller, there are certain things you keep in mind because you're the first point of collection of data. You're the one making the decisions about the individual. You're making decisions about the data. So the responsibilities that will apply to you in this role may be different from, let's say, you are providing a service to another company. You are a vendor to another company is using your product where you're a processor. So the responsibilities that may apply to you as a processor would be different. So it's important to understand this distinction. And so now we go to what really is the compliance you should keep in mind. Now, like I mentioned at the beginning, there are different laws across the world that will apply. However, you can choose to put a baseline and put that baseline, keeping in mind these data protection principles we spoke about. And you can also put in the baseline following the GDPR. So what I have put in here is are some of the controls you can consider while putting in this baseline. First thing, you have a duty to inform the data subject. First and foremost, you're collecting data from an individual. You have to let them know what data you collect, why do you collect it, how do you use it, whom do you share it with, how do you protect it. You have to inform them. So how do you do that? You have a privacy notice, you have a privacy policy, and make sure you keep it updated and to reflect what you're actually doing. When you are collecting data of individuals, it's also natural that they have some control over it. They have some rights over it. So they do have a right to reach out to you with questions. They can ask you, what data of mine do you have? Can you give me a list? Uh, whom do you share it with? This data is not correct. I want to correct it. I want to update some information. I want to port it. Or I want to opt out of your database. I want to opt out of your list. Please do not use my data in this way. Individuals have that right. So they can reach out to you and you have a duty to respond to them. So how do you do that? You need to put a process in place whereby you can track the request of these individuals. You can respond to them and keep a record of it. It is important to respond to individuals when they have questions about their data. Thirdly, you yourself, for good governance in the company, you should know, you should have an inventory of what data you have. You will not be able to decide what security measures to have. You will not be able to decide uh, what assessment I need to do if you do not, in the first place, know what data you hold. So it becomes important to maintain internal records. These are called processing records. And there you will keep track of what data you collect, where do you collect it from, how do you use it, who all has access to it, where do you store it, how do you share it, etc. Now, many a times you are not the company doing all the work. You do engage vendors. For example, you have a vendor, you have a cloud service provider, or you use another vendor to send emails. So they become your processors, and it's important that you pass on your responsibilities also down the chain. So you need to pass on these responsibilities to your processors. And how do you do that? You enter into agreements with your vendors. You enter into agreements with companies or people that you further pass on personal data to. And these are called data processing agreements. And these are some things you have to sign when you engage a vendor who will receive personal data from you. Then comes the question of transfer. It happens quite often that your headquarters is in one country, your data center is in another country, you have staff all over the world. So the data you collect does travel around the world. And there are laws, especially the GDPR, which place a restriction on transferring data. It places certain conditions when you have to transfer data outside its origin country. So make sure that you know where you're transferring this data to, and in case of GDPR, you know that you have a legal basis to do so. There are many options available under GDPR to legalize transfer, with the most common one being signing something called standard contractual clauses. So make sure you have a list of the transferees outside EU. Make sure you have these SECs signed with them. The next is a very important step. Whenever we talk about privacy, we also talk about data protection. That is, you protect data from unauthorized use, unauthorized disclosure, from data breach, from data leaks. You have to put in measures in place. So you have to identify the correct security measures. You have to have security policies in place. You need to have logs in place to see whether there has been any unauthorized access. And if feasible, you can also have some standards like ISO 27001 or SOC 2, which ensures that you have been audited and someone has certified that you have these measures in place. And lastly, you need to have an internal governance mechanism. That is, internally, the company should have a way to track how its employees are doing with respect to privacy and data protection. Does everybody know what they need to do? Are we thinking about privacy from the time of building the product itself? Are we making sure that we don't build something which unnecessarily collects data? Am I doing periodic assessments to update my processing record, to update my privacy policy, to see if there is some data at risk? So these are all internal governance mechanisms, and this is also something a company should put in place, and it's easy to put in place. So you can conduct periodic privacy impact assessment, do privacy by design, have internal policies, have internal security policy, privacy policy, train your employees, teach them what privacy and data protection is and what's their duty as an employee of this company. And if feasible, appoint a DPO. So you have someone in the management overseeing all compliance. This is the most, this is the easiest and the best way for controllers to approach compliance. And when you have a basic framework like this in place, as and when you grow, when there are some specific requirements, say under CCPA, it will become easier for the company to just implement it because it's a strong foundation to start from. We now move on to what happens when you are the processor. Till now, we saw what you need to keep in mind when you're the one collecting the data, making decisions about how to use the data, why to use the data, etc. Now, what should you keep in mind when you are a vendor to someone? What should you keep in mind when it's your customer who's passing on data to you because they're using your product, because they're using their tool? How do your responsibilities change? The first thing you should do, ideally, is you should know what data your customers are passing on to you. So again, you maintain internal processing records. You need to know what kind of, who are the categories of data subjects, what kind of data is coming through to your product, whom do you further share it with, where do you store it, how long do you retain it, so that when the customer has a question, you'll be able to answer that. And the next step, of course, is if you are using vendors, you have to pass on these responsibilities to them. Again, the same example, you are using a cloud service provider, say, or some tool to which has a feature in your product, and therefore the data goes to them. So you need to ensure that you sign a DPA with your vendors and sub-processors. So you give comfort to your customer that it's not just me who's taking care of your data, but I'm also making sure everyone down the chain is taking care. Third, which is common, is you protect this data from unauthorized access, use, or disclosure. This is something we already saw. Make sure you document the security measures, make sure you're testing those security measures. If possible, have standards, audit standards like 27001 or SOC 2. If possible, share the report with your customer. So that there is an independent verification that you are protecting the data you're collecting from your customers properly. Then comes an important responsibility. You have to help your customer when they have to comply with their obligations under law. So the customer, being the controller, will have the same obligations that controllers have. They might get questions from data protection authorities. They might get questions from auditors. They might get questions from individuals. And because they are using you partly to process data, they will come back to you for certain help. So you should be you should have mechanisms in place to help your customer when they come with requests. For example, they need to delete data from your product. They can't do it on their own, and they come and ask you. You have a responsibility, you have an obligation to help them do that. Um, if there is data breach, you should have a mechanism to report the breach to your customer. So you have to make sure that you are aware that the customer neck is on the line at the end, and therefore you have mechanisms to help your customer. And data transfer, similar to what we already saw, especially for GDPR or the UK GDPR, there are restrictions when you transfer data outside the EU. So you have to make sure you know where the data is going. You have to make sure that you have a legal basis for transferring the data. And you have to make sure that you have some transfer mechanism. For example, if there are standard contractual clauses, make sure you're signing these SECs with the transferees. A very important part of a processor's responsibility is you have to listen to your customer. You have to comply with their instructions. So what do we mean by that? It means where the customer has signed an agreement with you and has told you this is what you can do with my data, that is all you should do. If you want to do anything else, you have to reach out to the customer and get their approval. So make sure that you know what you have agreed with your customer in the contract and the DPA. That contract will be the customer's instruction. So make sure you know what is in there and you follow it. For example, it will say, if you engage a new sub-processor, let me know within 15 days. So you need to keep track of this and you have to make sure that you inform them within 15 days. It will say, if you hear from an individual directly, pass on the request to me within 5 days. You should know that you have agreed to this and you should stick to that. And lastly, you need to have internal governance, whether you're a controller or a processor. Similarly, you do periodic privacy impact assessment, you have privacy by design, you have privacy by default, you have internal policies. So your employees know that considering I'm working for this company and my company has certain obligations, I also have to abide by it. So make sure you have policies for your employees, train your employees on these policies, and if possible, appoint a DPO. Now, you'd already see that there are overlaps between when you're a controller and processor. So it's not very daunting. These are not very difficult things to put in place. And what happens if you do not follow these regulations? Now, a lot of times the perception is, oh, there will be some fine. There will be, I will be asked questions by data protection authorities. But that's not the only risk. Yes, there may be fines imposed by the data protection authority or the courts, there may be penalties, but that's not the only risk. You can also get a lawsuit from your customer because your customer is entering into a contract with you, which you're not keeping. So there's the risk of a customer lawsuit. Individuals who have been harmed, let's say there's been a data breach, someone's social security number, password has been leaked. The individuals have a right to claim a compensation from you. So there's a risk of claims from data subjects. Reputational harm. Now, when a fine is imposed, of course, it will be made public. There will be information available about it. For example, recently we all know Meta has been fined many times over in the EU. Google has been fined. And we've been told this is what they're doing wrong. So there's also a reputational harm. And often there is again a perception that there is a risk only when there is a data breach. Only when there's a data leak or there's unauthorized access or disclosure, that's the only time I have to be worried about privacy. Again, that's not the case. If you don't comply with your other obligations, for example, you don't have a privacy notice, you're not signing DPAs, you're not signing SECs, you're not responding to a data subject's request, you don't have a proper legal basis, you're not deleting data. All of these are also violations. And all of these also bring risk of non-compliance. And it's not just data breach. Now, we saw what businesses need to do, what companies need to do, and where do you begin? If you are a startup and you don't have the time or resources to do it elaborately, how should you start? You start by first mapping your data flow. Understand what data you process. Start putting in place records. These are all low-hanging fruit. It doesn't involve much effort to put in, but the benefits are a lot. Secondly, once you know what data you have, you then figure out, okay, am I the controller? Am I the processor? Am I the business? Am I the service provider? What role am I playing here? That's the second step. Again, easy to do, not very hard, no hanging fruit. Third, you then map the obligations to your role. So you know this is the role I play for this data. So let me now understand what is it that I need to do. Here is where we need to spend a lot of time, because here is where your obligations will change depending on which country's law applies to you. Everyone is very aware of GDPR. GDPR is one of the strictest privacy laws in the world, and almost everyone takes effort or takes a decision to comply with it. And there are also laws other than GDPR. So you can spend time in understanding what more do I need to do. For example, are you a business operating in California? So how do these change when I am collecting data of California residents? Do I collect health data from the US? How do these change when there is HIPAA? India protects sensitive data. So what do I do when I'm collecting data of people from India? And India is also coming up with a new law. It hopefully gets passed in this budget session, which again has a lot of similarities with GDPR and also some differences. For example, India is taking the stand that you need to localize a lot of data. So you need to understand, if I have data of Indian residents, do I need to post it in India? What should I do about that? India, you have a strict breach notification. If it's a serious breach, you have to notify it within 6 hours to serve. So try to understand that. So the best way to go about it is to start maybe in GDPR and then also to branch out as and when you have the scale to do that. The fourth thing, which is not very difficult to do, but companies may find it cumbersome, is make sure you're transparent about the personal data you process. Now, sometimes companies feel that this may affect my business. If I give too much information, I may put people off from subscribing to my product or from signing up on my website. This, you can balance it very easily. Going back to these principles that we saw, one must always remember that data belongs to the individual, and you're using it, you're monetizing it, but in the end, it's the individual that owns it. So make sure there is a level of transparency about the personal data you process. Make sure you have a good privacy notice. Make sure it's updated. Make sure it reflects what you're doing. Lot many times Companies just copy paste privacy notices from somewhere, they just auto generate it. And when you look into it, there is no connection between what they are doing and what the privacy notice says they're doing. That's not good. So make sure you have a proper notice. Make sure you maintain accurate records. Make sure you have proper policies internally. Make sure you're signing agreements with your vendors. And while these may take some time and effort, it goes a long way in ensuring that you're complying with the law and also ensuring transparency for personal data. And lastly, privacy and data protection is something that has to be baked into the culture of your company. So it becomes important that the management sets accountability. And whenever there is a culture of privacy, you don't feel the strain of putting in controls or putting in security measures in place. So that is a good place to start. And finally, train your staff and create awareness. Many times, the leak happens because someone lower in the chain in your organization does not know what to do. So they may not delete data properly, they may leave passwords lying around, and sometimes you have to ring fence you the people also to make sure you train your staff and create awareness. These are all very doable, irrespective of scale. And what it results in is credibility with your customers, um, a good culture of governance within the organization, and also credibility with your with the individuals you're collecting data from. It could be your employees, it could be candidates, it could be event attendees, it could be your partners, it could be anyone. And finally, keep calm and call a lawyer if you have any questions. And I think this is a good point to go to the questions. Okay.
Akshay, that was really a very insightful session, and I hope all our listeners have found a lot of value from it. Thank you so much for that session. So now we are open for Q&A session, and we already have some questions. Okay. So the first question is, what are some common mistakes that startup make when it comes to privacy and data protection, and how can this be avoided?
Sure. So the most common mistakes they made is they do not have basic, the bare minimum controls in place. So what do I mean when I say bare minimum? Your external facing privacy policy. Many startups don't publish this policy. So when a customer who knows about privacy wants to find out what is it that this company is doing, they come to the website, there's no privacy policy. That is one. Second, a lot of them do not sign up agreements with customers without understanding what mandates of privacy are there in that agreement. And so what happens is there is something signed with the customer, and then a year later, the customer comes and says, hey, I need to do an audit. And the audit finds out certain discrepancies, and the customer gets a little pissed off. So that's another common mistake. So make sure you have proper contracts that you sign with your customers. Very easy to do, but this is not a priority for startups. The priority is more of product and marketing, so these get missed out. And the third thing is a lot of them don't think it's important to think about privacy when building out the product itself. Because like I said, the priorities are different when you're a startup. Revenue is your priority. Compliance is not really a priority. And what you can do is just make sure that when you are building out the product itself, you keep in mind that let me only collect data that I need. Yes, my marketing team may want not many things, but let me be a little respectful of the individuals. Another mistake that startups make, indiscriminately marketing in the EU. So cold calls, recording the calls without consent. There are a lot of email campaigns that happen. The email is not clear on a lot of things. And a lot of complaints, at least in EU, they do come from these marketing emails saying, I did not ask for this. Why has this come? How did you get my data? Where did you get my data from? Are you scraping data? So these are some of the common issues that startups face when it comes to privacy and data protection, all of it equally easily fixable.
Okay, that is really helpful. So the second question is, what are the most important laws around privacy and data protection that startups should know about?
So I would say start with the GDPR, which is in EU. UK also has a version of GDPR. So I would say EU and UK GDPR is something you have to start with. The California Consumer Protection Act is also something that you can start with. And if you are dealing in specific sectors, for example, health sector, then you should know the laws that apply to health sector, like HIPAA in the US. If you are operating in the financial sector in India, you should know the RBI regulations around data localization. So you have to start geography, maybe you can also sector-wise.
Okay. So the next question is, what are some examples of successful startups that have prioritized privacy and data protection, and what we can learn from them?
Uh, Successful startups, I'm sure there are many, and I wouldn't want to name them because there could be many and I don't want to pick and choose. What can you learn from successful startups is that they have a very high credibility with their customers because they demonstrate that privacy is important for me. I think about it. I know about it. I worry about it. So even the customer becomes very comfortable using this product. So a high degree of credibility from the customer is something you can learn. Equally, individuals may actually be quite happy interacting with you when they get the right information, when they know why their data is being used. They may be happy to get sales and marketing emails from you. So that is something you can learn from.
So the next question is, and I think this is a very good question, how can startups stay up to date with changes in privacy and data protection regulations and best practices?
Okay. So the easiest way for startups to do that is maybe have certain certifications in place. ISO 27001 is very common. SOC 2 is very common. There are also many organizations that help you with GDPR controls itself. It's easy to sign up, easy to put in place. That would be the easiest way for startups to be up to date.
Okay. So we have last two questions left. Uh, what are some emerging trends in privacy and data protection that startups should be aware of?
Yeah. So there is a lot of productization of privacy and data protection, which is a very positive trend. So you have a lot of tools in the market to help you with compliance. For example, cookie compliance is a big issue in the US, EU. You are supposed to get the consent of the website visitor before you drop cookies. You are supposed to tell them, give notice of what types of cookies are there. You should allow them to disable non-essential cookies. So it seems like it's a big thing to do, but there are many tools now available which will help you manage cookie consent. Similarly, companies find it daunting to respond to requests or questions from individuals. How do I keep track of this? How do I respond to this? How do I keep track of the response? Again, now there are products to help with that. And there are also products to help with mapping your compliance, where you can list out what is it that you have done, you can assign responsibilities, you can set cadence for monitoring. So this trend of productizing or technology aiding in compliance for privacy and data protection is very encouraging. And that is something startups should be aware of.
So this is the last question. What are some of the upcoming privacy and data protection problems for startups?
Yeah. So one of the most common problem is the fact that while your business is global, the laws and regulations are territorial. So you will get data from different parts of the world, and customers from different parts of the world will come and tell you, okay, I know you know about GDPR, but you should also comply with the Philippines Privacy Act or the Brazilian Act or the South African POPI. So for startups, it's an issue. What this will become more and more prominent as more and more countries come up with their own privacy and data protection law. How do I deal with this? That's a question we have to answer. Secondly, specific to India, I wouldn't call it a problem. I would call it more as a challenge. Is India will definitely have its own privacy and data protection act, which going by the bill now is a different approach than GDPR. It does place a lot of importance on consent. It creates certain categories of companies which have more compliance, which has to mandatorily have some audit and TPO. And the biggest elephant in the room, of course, data localization, where in India, uh, there is already localization requirement for under certain telecom laws for banking data, payment system data and all. But it is definitely something that companies who are operating in India should watch out for. And when I say operating, I mean offering their goods, offering their products, offering their services in India, targeting Indian residents, profiling, advertising. That is something startups should watch out for, which will come soon.
So thank you, Akshay. This was a very insightful session, and I hope that a lot of our guests will get value from this. I also like to thank the guests for joining the session. And if you have any more questions, you can definitely email us, and we would be replying on each of your queries. And I think we should wind the session now. Thank you. Thank you so much.
Mhm. Thank you, everyone.